almost a year to the date that these murders happened here in Moscow. We know that one of the most important pieces of evidence is, of course, the defendant's DNA at the crime scene.
It impacted like a lot of people on campus.
Yeah, most people try to not bring it up because it's a sad subject to bring up upon, but everybody knows what happened and everybody mourns it and everybody's upset about what happened.
We never go to the bathroom alone, never leave anywhere alone.
No, I hope he gets put in jail or prison for a while, yeah. And most people here do, nobody likes him.
All right, welcome back to Opening Statements. I'm Ted Rowlands in for Julie Grant this morning. She'll be back later today. She's filling in for Vinny all week. Let's talk about this DNA and Brian Kohlberger, the case, of course, in Idaho, the Idaho murders. The court has now said, we're going to give you a deadline to deliver this information, and the judge is going to look at it and parse out what will be given to the defense. Basically, what is happening here in Kohlberger's capital case is that prosecutors have to hand over the forensic records from the FBI to the defense through discovery. The state has until December 1st to retrieve the items. The judge plans to look at the documents and then decide what goes to the defense and what doesn't. The prosecution and the defense have battled over this issue, this DNA issue, since the spring. But the question is, does the defense deserve all of the records through discovery? Let's bring in our guest state attorney in Palm Beach County, Dave Ehrenberg, former criminal defense attorney Kirk Nurmi, and jury consultant, human behavior expert Susan Costin. Good morning to all of you. Dave, we've just talked to you, but good morning, Kirk and Susan. Let's talk about this. And the reason this has manifested itself, you have the original DNA was put through the criminal database, no hits. So investigators throw it into the public realm, and that is where there is a hit, and it's to Kohlberger's father. And this is, the 23andMe ancestry DNA scenario. So now the defense is saying, wait a minute. Yes, you've swabbed the guy and it's a hit, and we get that, but we want to know how you got there and what did you get from this, and how did you go about this? Because there are rules in place, but it's an emerging scenario because this isn't done very often. Usually it's cold cases. So Kirk, to you first, does it matter? Because as a member of the public, all I want to know is, does the DNA in the knife sheath match the guy you have at the defense table? And that seems to be clear. Why do we care about how we got here?
Well, we care for several reasons, and the answer is ultimately the defense is entitled to this. And Ted, we have to keep in mind that between the time someone's sentenced to death and the actual execution of that sentence, there's over 10 years lapse, and the law can change. And defense attorneys in a capital case have to kind of anticipate and be conscious of those possible changes, which is why we saw Brian Kohlberger's defense team argue the probable cause, that a higher standard of probable cause than the indictment should be offered, because they think the law might change. And here in this situation, we see this new emerging field, and they are going after DNA evidence in this new area, if you want to call it that, and they're entitled to it because down the road, some point in time, even if it's not directly entitled under Idaho law, the law could change and say, yes, in these circumstances, they're entitled to all this paper trail. How did they get there? I think that's a fair question for the defense to be able to discern and have their experts look at when they go to trial. And if I'm the state of Idaho, why would I want to risk the possibility of a new trial in those 10 plus years by not giving over this information? What are they hiding, if you will? So I think the defense is completely entitled to it, and it matters because this is how the match was made, and the defense is entitled to explore the validity of that.
Susan, DNA has had quite the journey in terms of jurors. You go back to OJ, and it was a scratch your head, didn't figure out. Barry Scheck was able to confuse everybody. Now, thanks to crime shows, et cetera, DNA, they can't wait, right? I mean, DNA is a prosecution tool like no other time. Give us a sense of how jurors take the DNA and how much they really have accepted it.
I think that today, because of all the crime shows that we have and shows like Court TV, jurors are looking for that. They're looking for the nail in the coffin. What will link them to it? What is the proof? you know, when we look at the jury pool, if they're more subjective, they want to, those are the people that kind of have this tends of self-doubt. But most likely, people are more analytical. They want to be able to subjectively and objectively look through all of the evidence and come to their own conclusion. And I think by withholding it only allows him to subjectively choose if he was innocent or not. And then, but the data that came from the DNA evidence is a very crucial part of this entire case. Why shouldn't they have it?
Prosecutor Dave, why not? Why would the state not want everything out there right now? How the FBI did this, there are guidelines, but it's not firm in terms of using these other websites, the public websites. What's your take? And is this just in something that's going to be inevitable? At the end of the day, everything's going to be out there.
You know, Ted, up to a point, I do think the defense should get at least some of this information. I agree with the judge's ruling. He's going to look at this in private and then determine how much should go to the defense. But you said something that I was not aware of. You said that the father was the family match. Has that been shown to the public yet? I know eventually they pulled the trash from the father at his place in Pennsylvania, but to me, the reason why the prosecutors don't want to give this up is because they don't want a family member, whether it's a cousin or whoever was identified as Kohberger's family member, to then become a red herring at trial and harassed. And they don't want future relatives who will agree to be in the DNA database to be subject to harassment, or else no one else will agree to be in the database, and then law enforcement will be stuck on cold cases or anything else in the future. So yes, you can have information that guides you to where you need to go, but as far as being able to harass a distant relative who had a DNA match, no, because Kohberger has no privacy rights in his relative's DNA, only his own DNA.
Good point. Yeah, and that is it makes perfect sense. And the red herring scenario is going to absolutely be a factor here. As Kirk pointed out, this is a death case. Everything's on the table. And it's not just the trial, it's the years after the trial, if in fact there's a guilty verdict with a recommendation for death. So we'll see how that plays out. Let's switch gears now to the alleged murderer, convicted murderer, Alec Murdaugh, and his attorneys asking for a major shakeup of their request for a new trial.
All right, Mr. Murdaugh, I sentence you to the State Department of Corrections on each of the murder indictments. In the murder of your wife, Maggie Murdaugh, I sentence you for a term of the rest of your natural life. For the murder of Paul Murdaugh, whom you probably loved so much, I sentence you to prison for murdering him for the rest of your natural life.
Judge Newman, he's the best, right? We all love Judge Newman. Well, Murdaugh's team wants him out. Lead attorneys Jim Griffin, Dick Harpootlian is saying that Clifton Newman has a conflict of interest which would prevent him from presiding over a new trial if given one to Alec Murdaugh. Of course, this is stemming from the defense allegations that the clerk, Becky Hill, pushed jurors to return a guilty verdict and help secure herself a book deal. Griffin outlined the allegations during a press conference back in September.
So immediately in the aftermath of the verdict, we had received information that we needed to look into what happened in the jury room. When the clerk of court wrote her book, published her book, that zone of silence collapsed. And jurors were upset about that, the ones we talked with, and they were more than willing to come forward and tell us the things that we had sort of heard through a whisper campaign. The first juror we talked to, we got information about Ms. Hill saying, "Don't be fooled." And then the second juror, independent of the first juror, says the same thing, and the third juror, independent of the other two, say the same thing.
Now, these are still allegations, of course, against Becky Hill, but the question is, should Judge Newman be removed from this case? Dave Ehrenberg, to you first. What's your take on this defense ask?
Well, only if Judge Newman is a witness in this matter where he witnessed the clerk being inappropriate, then yeah, that would be a conflict. But if he's not a direct witness, then no, he should not remove himself just because he said some words on the bench why he found that this individual, this defendant, should be sentenced to life in prison. That's what a judge is supposed to do. And the fact that he spoke to the media afterwards, after the case is over, I don't think changes my view on that.
Susan, let's face it, Judge Newman and Becky Hill know each other quite well. And when you have that human interaction, isn't it safer to eliminate that potential problem?
Well, it certainly is a conflict of interest, and it can be. But watching Judge Newman throughout that trial, I know, and you can sense that even with how he handled the entire trial, that he is not going to take a position. He is very neutral. But based on the evidence, that's why he came to that conclusion. He was basing it on facts, but he also shared his own opinion. But I don't think that he would be unable to set that aside and be a fair and impartial judge during this next trial, if we even get one.
Yeah, that's a big question. Kirk Nurmi, if you're the defense, though, it would be nice to get rid of Judge Newman, right?
Well, yeah, I think it's premature to ask for his removal for a new trial or for the fraud trial or anything else, because obviously we're not there yet, and he hasn't shown bias as it relates to the fraud trial. But I do disagree with the idea that he should be presiding over this motion for new trial. It's his clerk. He's going to have bias, whether he's a witness or not, and the standard is appearance of impropriety, whether it's actual impropriety or not. There's no real reason for him to preside over this. Another judge could handle the situation just fine, and I think that would be a cleaner record moving forward, because we know Murdaugh is going to engage in endless appeals. So I think it's cleaner with that appearance of impropriety to simply have someone else preside over the rest and then see where the chips fall after that.
It's going to be fascinating to watch all unfold there. The Murdaugh saga seems never to have an end to it. Let's get a break here. We want to thank Kirk Nurmi and Susan Constantine. Dave's going to stick around. Here's what's coming up next on Opening Statements.
Did you know Dan Markel?
No.
Do you know why Garcia or how Garcia